We
And we're
good? All
live.
right. Hi, this is Curt Barone,
And Brad Pinsky.
and we're here for another edition of Fire Law Roundup for July 21st of 2025. Brad, go ahead.
So the first one, let me just make clear, these are allegations. We don't know what happened, but if the allegations are true, oh my freaking Lord. This stuff, if true, and you just presume I've added that before everything I ever say, if true, if this is true, is so disturbing. So we're going to go to Frederick County, Maryland, right? Virginia, I'm sorry.
Yeah.
We have a lawsuit for $50 million. And I will tell you, when I got to the first paragraph, I'm going to go through the facts, but as when I got to the first paragraph, I'm like, look, nobody's ever going to win under these 1983 violations. Maybe Monell, where they say they have a policy and a history, and I hadn't even gotten to the facts of it. I'm just starting with your summary, and I'm like, these lawsuits are all a waste of time. And then you read the fact or the allegations,
Yeah.
and wow. So here's allegedly what happened, and note to everybody, this is not the first one related to this. You and I covered a prior, well, we'll get to that, but we covered another related one. So let's just go through this. So here's the allegations. They said that there's a long-standing culture of abusive training in Frederick County and Fire and Rescue's Department Recruit School, and this is going to involve the training of recruits. At jumping to the end, we have one of the recruits who is only age 35, died in July of 23, second day on the job, first day of physical training, after he was participating in this high intensity outdoor exercise session. And they called it allegedly Hell Day. Now, I will start with this. I remember when I started, probably you too, probably a lot of our viewers, they started in the fire service, and they did. They ran training like a military, right? Like a
We didn't.
military.
Let me put that. We
Oh,
didn't. We didn't.
okay.
And the guys that trained us were World War II veterans. So
Oh, wow.
yeah.
Okay.
So it's like something happened between World War II and today, and I don't know what it was,
Yeah, well,
but
when I started training, even from one of the first trainers, they were creating hectic, loud situations. And then the same trainer to me says, I won't mention his name, but a good friend, but still, but he says, fire scenes aren't supposed to be hectic. Fire scenes are supposed to be calm as we can make them. So this yelling at you to create this hectic atmosphere is exactly the wrong thing. And then my county, who provides the training, and the state of New York generally stops. So that's, this shouldn't happen, but here we are. So what we have is this alleged Hell Day. It was apparently with a heat index of 110, although I think I remember the actual temperature was in like the low 80s or 70s or
it
something.
started low, but then it escalated quickly. And that
Right.
was one of the things that they apparently miscalculated.
And they had, for this reason exactly, they had heart monitors on
Yeah.
everybody.
Which is pretty
Mahler,
progressive. I don't know how
very.
many departments do that. I mean,
I never heard of these specific ones. I've had people wear watches, right? And they would come out and immediately check you, which isn't great to wear into a live burn. But nonetheless, these polar H10 sensors show the heart rate and show that this individual who's now deceased had an elevated rate way over the normal or the safe limits of for over 30 minutes, and
Mhm.
that they knew it, right, but failed to intervene. So they go through the training, and you all should read it. It's a long read, but it's worth looking at every line. Some things you'll see is, they had them take off, they had them load water coolers and sandbags just to start the day. This wasn't even the alleged beginning of the training, right? So they load them, and then the guy asks a loaded question, apparently, how many sandbags were there? And everyone's like, we didn't count. So they're like, okay, unload them and load them again. And this is before the work. That's like saying we're going to go on a call, but what we're going to do is we're going to work out the entire day to make sure you're exhausted for a call. That's not realistic in any way, in any event, if true. So they then continue to, well, so their heart rate's already elevated. And this one guy's apparently to 184 beats per minute, which is way at the top of the unsafe or safe range, right? It's in the unsafe range now, dangerously unsafe. So again, they talked about they could have done the training inside. They instead did it outside with a heat index of 110. And then it just gets worse. So it just starts, they're getting yelled at, demeaned, derogatory, and the important part, threatens them that if they don't keep up, they would be dismissed from the recruit school. So what's anyone going to do once you're told you fail, you're going to be dismissed? So they don't get water breaks regularly. They have to search for their water as one of the drills as a team, and they can't have it until they're, till they find it. Obviously, that would be not consistent with a normal state's training protocol, if true. They knew allegedly, right? They claim they're even talking to the guy about his elevated heart rate. And the instructors are apparently talking about this elevated heart rate, but they do nothing about it. And then we find out one person who's leading this, I guess, or the physical trainer, wasn't even trained properly in how to use it, how to read it, didn't know what was happening. So we get to the end after this allegedly hellacious training, and now they're going to do bear crawls after this short break. And the deceased can be seen just after a couple of feet going down to his hands and knees, and they're yelling at him, "Get off your knees, get off your knees," in a demeaning tone. He, keeps going down, and then ultimately, when he's told to get to his feet, and they don't get it right. So he's ordering him to do it again. I mean, they're already exhausted and dropping, and he's allegedly ordering him to do it again. It just goes on and on for pages about the stuff they were put through. Now the heat index gets to 116 to 124 degrees, which NFPA is clear, and they raise it, should never be out in that intense heat. The guy collapses to the ground during a run. His blood pressure is still elevated. And then ultimately, he goes down, just slumps over. They can't get him back. They dispatch the ambulance. And then allegedly it gets worse even after dispatch, because they exclude, well, his body temperature is 104, which is insane, but they exclude that from the PCR. It appears to be, the allegations are that they started, trying to cover it up, that they knew what was done was wrong. And so the allegations are they didn't report it. Apparently state OSHA investigated, but there are some documents they didn't get. And then when they were anonymously provided to them, gets us back to our prior story, then OSHA gets involved, and they realize, they issued a positive directive saying there were violations.
This is not the first time we've seen these kinds of allegations. Now, I'm not talking about Frederick County. Okay?
Or about Watertown, New York.
Right. Well, there's another example.
I see it different.
Well over a couple of dozen cases that have happened on strikingly similar facts. And this is not about somebody being a bad instructor or having ill intent, or it's people with the best of intentions. I'm giving them the benefit of the doubt. The instructors had the absolute best of intentions here, but what they allowed to happen is indefensible.
Right.
Indefensible.
And maybe the reason, let me just know that one of the guys apparently is in premier physical shape, one of the instructors, so maybe that's the reason he doesn't see it.
I got to tell you, if that was my son, I thought a lot about this. If that was my son, he would not have to be worried about being sued.
Right.
He'd have to be worried. No,
right.
His estate may have to,
right?
But he'd have to worry about every step he took. Honestly, if they pushed my son, one of my sons like that,
right.
It's easy to be objective when you have distance from something like this, and that's why we have our legal system that is going to take something like this. But it kind of flashed through my head that if this was my son that was pushed like this and he died, for
Yeah.
what?
Right.
For what?
Right.
What are we trying to accomplish
And
here?
none of this is realistic. It wasn't even realistic training.
Well,
It didn't reflect the
I go
job at all.
my youngest brother, who may be listening, he, from his office often he'll listen. Billy went to the dark side. He became a police officer, but before he became a police officer, he was in the military, and he'd been in the military, special ops and a bunch of different things, but he wanted to become a drill sergeant. And in order for him to become a drill sergeant at boot camp, he had to go through, I forget, it was 7 or 9 weeks of training on how not to kill a boot.
Yeah.
You can't.
Yeah.
You're going to be court-martialed if
Yeah.
you're a drill sergeant. And you know what? You don't get any more hard ass than a drill sergeant.
Right.
But they went through the training in addition to the competencies that you've got to have.
Right.
You've got to
Right.
be competent in not killing recruits and
Recognizing signs and symptoms of
how
people
far you
who
can
are
push them physically, how far
right.
you can push them psychologically. And if any fire department is thinking that this is a good idea to run their academy like this, what sort of training are you giving to those people? Because, and again, in the military, if you're a drill sergeant and you kill someone, you will be court-martialed.
Yeah. Yeah.
Okay. So there's no, oh, well, it's understandable. Oh, it's going to happen. No, it's
Right.
not.
Right.
And you're responsible to make sure it doesn't happen.
Right.
And you still have to train them.
There you go. I don't know where the old school, mentality still perceives. Now, I do want to differentiate. I don't want to talk about Watertown, but there are varying degrees of this, right? The Watertown case, which is so permeated through Watertown, New York, where the Watertown recruit goes to the State Fire Academy. He's being put through the maze, same maze I've done a lot of times. And he is allegedly having difficulty breathing. And the line was, if you can speak, you're not having trouble breathing. Right now, I can see that, but let's just call these varying degrees between maybe that at its lowest level, whether it's permissible or not, it's not my call, and this at its worst level. You don't want to be anywhere in between there, right? There's if somebody says they're having trouble, you stop, end of story, and you evaluate them with the medical team who should be on site when you're doing these types of activities.
Well, and the fact that they had those monitors, and I do wonder, there was an incident earlier that led to a lawsuit. The link is in the article if you want to go back and read that lawsuit, but they're intimately connected. Okay. But I do wonder whether or not the heart monitors that they were using in 2023 was a result of the complaints that happened from the 2022 incident. Okay. But kudos to the department for having those. That's great.
Yes, of course.
But
use them.
Oh my God. I don't know. And again, let's be honest, we are looking at one side of the allegations. And I have yet to read a lawsuit where when you hear the other side of the allegations, you don't get a different perspective. But
here's the interesting thing. The interesting thing is clearly the lawyer's not there. Clearly the dead guy's not speaking, and clearly the parents who are leading this weren't there. So they must have had a lot of witnesses from other recruits giving this story.
Yeah. No, for sure.
Hopefully it's not true.
Now, one of the things, let's kind of pull away from the reality of this and get into the legality of it. We've got a single count, which I thought was kind of interesting, and I'm not sure 100% why they went this route, but they went with a single count of Section 1983 deprivation of due process, deprivation of life without due process. Yeah, that's exactly what I thought.
Do they claim Monell as part of that they had a policy of doing this? Because
they didn't. I didn't see the details of the legality. There's only a couple of paragraphs there. But I just thought,
Fourth Amendment, life, liberty. I mean, I could see a couple of things.
My mind goes more toward tort on this, and trying to maybe get around some of the normal
intentional
defenses.
Reckless. You got it.
That's what I'm saying, that
Yeah.
that you're going, it's not just negligence. There's probably going to be tort immunity. There may be workers' comp exclusivity immunity.
But not as
But,
against willful wanton conduct, most likely.
so that's kind of where I would gravitate toward, but they're not. And I'm not sure why. I'm sure they had their reasons. I don't think that was,
Statute of limitations. This was in 23.
it shouldn't be a statute of limitations issue.
In New
And,
York, it's 1 year
yeah, so
statutes.
I I don't know. I don't know, but I thought it was interesting that they just had that single kind. It's a 47-page complaint. Often you'll see 10 or 12
Agreed. Agreed.
complaints,
Causes of action. Yeah, no, agreed. Well, we're
Excuse me.
clearly going to hear more about this. Bless you. We're clearly going to have more about this. Okay, so let's go to Memphis. I feel for both sides of this issue, sort of. So the issue isn't that complicated. The union and the city have negotiations.
Mhm.
During the negotiations, they agree to a 5% pay increase, and the city council approves that, and the union both formally approve it. And then they get to an impasse where they can't agree on the final contract. This is a lawsuit which alleges that once the city approved the 5% and the union approved it as partial agreement, that under these impasse rules, the impasse doesn't matter. What you agreed on is in place.
Right.
I'm not familiar with that rule. I will
Mhm.
be honest. It doesn't make a lot of sense to me because typically there's horse trading. We'll give you this if you give us that. So I'm not saying that the rule doesn't exist. I'm not being skeptical in any way. I'm just not familiar with it.
Every state's going to be different when it comes to this. And what we have binding interest arbitration here in Rhode Island. Some places have binding interest or non-binding interest arbitration at a state level, but very often, and I'm not sure about Tennessee, but they have binding jurisdiction on a local level. So it's going to be either in the city charter or in an ordinance that's adopted by the city council. And so again, I'm not sure which of those types of collective bargaining they have. But the bottom line is, according to the lawsuit, once the council agreed with the city's proposal, it then became binding. And so
Right.
now it's a question, is it binding, is it not? And in many places, that would be a grievance. It wouldn't be a lawsuit. But
Yeah, well, the city then comes out and gives a 3%, stating, and again, I feel for the city, I get it, stating, listen, we have no money to
yeah,
increase it. And so instead of
you
giving you
shouldn't
zero,
have
we give
agreed
you
to it then.
three. Should have agreed to it. Right. I mean, and so I don't know if this, I assume the lawyer's not making up this whole
Yeah.
impasse doctrine, but if there's an impasse and they did agree on it, then they violated it. They should have been aware. What's strange to me, though, is this, and my normal play out, I presume a lot of attorneys played this way. I allege there's a violation. I send you a letter. I cite you to the statute. I say, listen, here's what you did. It clearly violates statute, right? And you spend some time on the letter and you hope the attorney says, yeah, you're right. And I'll tell you about 6 times, 7 times out of 10, most lawyers, at least when I send a letter, they say, yeah, you're right. Okay, we screwed up. We'll fix it. Okay, great. No lawsuit. All good. Here, you would think that would happen. They would cite it and that would have ended it. So I'm curious why they're getting to this, unless they're saying we just can't afford it and they're going to plead to the mercy of the court. We can't afford it, or the rule doesn't exist. That's why I don't know.
It's some of it's politics, I think. And it looks like I would imagine the city administration proposed 5%. The union proposed 7%. The city council might have said, why are you proposing even 5%? We don't
Can't
want
afford it.
5%.
Right. But they did
And
approve it. As you
well,
said.
and that's the thing, and they have a system. So, but I think what's unusual about this one, and it is Tennessee, so not a bastion of liberal labor law,
I wonder where you're
but
going with that. Okay.
right, but they do have collective bargaining, obviously. So now the question in Rhode Island anyway, the big question here would be if this happened in Rhode Island, do we file a grievance? Are we limited? Are we required to file a grievance because we have an agreement and you've breached it? So because if you file in court, they're going to say you're in the wrong forum. You need
Right.
to go to the grievance. Okay. The other option would be the state labor board alleging an unfair labor practice, a violation of the state. Okay. But again, I'm not sure what the law is in Tennessee in terms of, do they even have a state labor board? Is an unfair labor practice possible? So they took it to court. So we'll see what the city says. The city's lawyers are probably going to say, yeah, you should have done one of those other things,
Right.
and you shouldn't be here in court. But
right. So clearly the city has some reason they're not agreeing. So, okay, let's go to PA. I like this kind of educational purpose. So everybody understands there's a rule of law. I've won. Well, you don't win. Well, you do win on it. I've won and lost on it when I made these motions, but it's called standing. That not just anybody can sue for anything. So, for example, HIPAA. Everyone's like, oh, we're going to sue you for a HIPAA violation. No, there's no standing for an individual person to bring a HIPAA violation, right? So you can't do that. So the rule of standing means that you're affected in a personal, individual way, separate from the public, or that a statute or a law has given you, whoever you are, the specific ability to sue, right? And standing is the first threshold issue. Are you ever even allowed to bring the lawsuit? We're in PA, where we have a local government not-for-profit group, and their purpose of existing is to make sure that there's no mismanagement of government funds, et cetera. And so they brought a suit against a fire department where they're in a volunteer fire department, and against the city, I think, or the county or town, whatever it is, whoever they report to. Borough, yeah, whatever the hell those are, right? Townships, boroughs. In any event, so they brought a lawsuit against the department and the borough they work for, saying, listen, you've proven there was theft, but you didn't do enough to get it back and all this. And so without even commenting on the merits of their claim, the court correctly holds what we call the zone of interest test in New York. Same principle, that you have to be within the zone that the law you cite was meant to protect. So if you're citing a law, that law had to protect you specifically and not the public at whole. And here the court says, listen, you don't have any individual interest as this corporation just because you say you do, just because you say, well, our job is to look out for all of these, mismanagement issues. That doesn't give you the right to sue. And in fact, the court goes further, saying, listen, there's the attorney general, the comptroller, there's a whole bunch, police agencies, a whole bunch of entities who have the power, but you don't. Case dismissed, whether you're right or wrong, doesn't matter. You don't have the right to bring the lawsuit. And standing is a really tough question of law. I've spent, I will easily say, hundreds of hours in some cases where you're going after or you're trying to defend that you do have standing. It is so hard because New York State and many states like Pennsylvania use a concept that you have to be in the zone, in the area of the protected interest. And it's tough to prove sometimes.
And I think this is an important ruling. The reason why I included it is, every day I look at, anywhere from 3 or 4 to 10 different cases, and which one am I going to blog about? But felt like this one is important because we've got to understand the implications of standing. There's a lot of people out there that are upset with decisions that are made by fire departments. Okay, there may be somebody in your community that doesn't think fire trucks should be red, thinks they should be lime green. We actually had a lawsuit years ago on that. It's in my database. So,
okay.
yeah. So it was I think he was a ophthalmologist or whatever, but he felt like lime green was the right color and all this. Okay. Point being, there's a lot of people out in the community, and some of these people, I see the lawsuits. I see some of the suits that get filed, and usually they get dismissed. Usually it's somebody who is very prone to file a lot of lawsuits, okay? But they will challenge all sorts of stuff. And this is the issue of standing is an important protection for us. And it's the type of thing where a fire chief may be aware of, we got a lawsuit, but then the lawyer, all right, we'll take care of it. And they get it dismissed pretty quickly. So, but it is important to understand standing. And it is an important protection for us so that we can get get the work that we've got to get done without having every single decision, challenge. Should we buy a 95-foot tower ladder, or should we buy a 110-foot rear mount, or whatever it is. We don't want taxpayers intervening in those kinds of day-to-day decision making, which some may feel like they have a right to do.
Yes. Okay, so that's standing.
There you go.
Anyway, okay, so now let's go to where are we going? Oh, Texas. So also interesting holding. So and I really do agree with this holding. I haven't found too many I've not agreed with recently, but I really do agree. So we had the City of Houston's firefighters were in a dispute over unfair labor practice, impermissible payments, etc. And the union is right, the plaintiff, and they resolve through a settlement the payment of, what is it, 650 million to in back pay to the members of the union. However, the assistant chiefs were members of the union, but here's what happens.
Well, they weren't members of the union. They were firefighters. Uh-oh. Brad, you just locked up. Can you still hear me? All right, looks like Brad has locked up here. So, all right, I'll keep going. This was a case that goes back, I think it's over a decade. The settlement of that case, actually, yeah, 2011 was when, it goes back to. But bottom line is the firefighters resolved it. The assistant chiefs who were not in the union, but they felt they were under the definition of firefighters under Texas, and they're entitled to the same protections that the other firefighters in the bargaining unit would have been entitled to. So they were, claiming me too, that we should get the same thing. And I'm getting a text, and it looks like Brad lost his internet. I just got that text. So I'll wrap this up. And we'll see if he joins us. Fine. If not, we'll just go through it. So bottom line is a group of 13 assistant chiefs wanted to intervene in that original lawsuit and basically say, me too. There's some legal ramblings back and forth. You can read the decision there, but kind of a split decision. The trial court said that the assistant chiefs can pursue, they are firefighters, and to the extent that state law gives them the right to certain things, they have the right to pursue it. But they kind of ruled against the union, found that the assistant chiefs have the ability to sue the union for breach of its duty of fair representation, which is kind of strange because the chiefs are not in the bargaining unit. So, but at any rate, that they are going to be able to pursue that claim. So again, kind of a strange ruling, and it sort of is what it is. Okay. The last of the cases, and I'm sad that Brad's not going to join us for this one, because when I read this one, I said, oh, I remember Brad and I talked about this one. This is where the fire truck was on the ramp and it rolled out and crashed into a building. And oh no, this is another case. This one is in Kentucky. Virtually the same facts as the one we covered. I believe it was New Jersey. I don't know if I linked to it. Yeah, it doesn't look like I linked to it, but there's another case very, very similar. Now, this one is different. This one, apparently, the trucks on the ramp, they were having some problems. Trucks on the ramp, they moved the cab. They kind of, flipped the cab. And in doing that, I guess what they figure happened was something fell, hit the parking brake. Apparently the wheels weren't chocked, and the truck went out across the street and crashed into a building. So the facts are really that fact pattern is really what I thought was interesting here. It's not the first case like this that we've seen. I've got at least two. I haven't gone back in the database to figure out how many other ones we've got, but pretty clearly, this has happened before, and the legalities of this may be interesting to the lawyers. I'm not sure, but I do wonder now about the earlier case from New Jersey about whether or not it might be sort of a common phenomena where somebody's on the ramp and maybe they flip the cab to access the engine, and the next thing you know, something hits the parking brake and it's off to the races because the wheel's not chopped. So at any rate, the legalities of this one have to do with really kind of an unusual ownership situation here, where you have looks like a City of Somerset fire truck, but it is actually owned by the county. So the county owns the truck. The county is insured through the Kentucky Association of Counties, or CALF, I guess is the name of the insurance company. And so we've got some damage to the building, we've got some damage to the pumper. And the question is whether or not the insurance company can go after the city on some sort of a subrogation claim. The city is saying, "Now, wait a minute, we're an insured under the policy. When firefighters are using the truck, we are considered to be an insured under the policy," which makes sense. But from the insurance companies, they want to try to get some money back from the city because of causing the brakes to go off and causing the accident. So bottom line is the Court of Appeals has affirmed a lower court ruling basically saying that no, the firefighters were using the truck, even though it's on the ramp, they're making repairs, they were using the truck, and therefore the county's insurance covers them, therefore they are insured, and therefore the insurance company cannot sue the City of Somerset for some sort of a subrogation based claim for the damages they had to pay out. So kind of an interesting for the legal eagles out there. For the firefighters, I think the interesting part of this is really we have another fire truck on a ramp at a firehouse that rolls across the street and crashes into a building. So, chalk your wheels, I guess. So, all right, well, that's going to do it for another edition of Fire Law Roundup. Unfortunately, Brad dropped off, but hopefully we'll see him and you all back next week. Thank you.